Furthermore, I would point out to the representative that I dedicated 15 years serving as a state prosecutor long before she ever conquered her legal licensing tests. I am fully aware of how genuine proof appears. I understand exactly what an authentic inquiry resembles. Moreover, what I'm observing from your side of this panel represents absolutely nothing of the sort. The nation's chief law enforcement officer rested her writing instrument with the calculated smoothness of an individual who just delivered a remark deemed entirely unassailable. To her rear, a lineup of federal government lawyers remained seated with the specific vigilant motionlessness of professionals tasked with spotting complications well before they turn apparent to the general public. Up at the raised congressional platform, conservative lawmakers bobbed their heads in the cadence of individuals who were promised that the proceedings would unfold smoothly. The legislative chamber hosting this judicial panel during the early fall of that year possessed the distinct mood of an accountability session broadly anticipated to be pure spectacle. The Attorney General had previously provided sworn testimony. She was intimately familiar with the structured layout. She recognized which lawmakers intended to posture for the cameras and which individuals planned to pose genuine inquiries, while knowing exactly how to spot the distinction merely half a minute into their introductory remarks. She had made all the necessary preparations for those variables. She had utterly failed to ready herself for the Texas representative, though certainly not due to any lack of awareness regarding her presence. The lead official had already received comprehensive background briefings. She had reviewed the viral video segments and studied the representative's operational methods, noting her quiet composure, her organized binder, and the deliberate way papers were laid onto the desk with the endurance of a victor waiting for the audience to reach the identical, undeniable deduction. The witness had assured her public relations staff the previous evening that while the lawmaker was skilled, she herself thrived more during legal trials than congressional panels, adding that her opponent lacked actual trial experience. That statement represented the exact sort of reassurance one voices the evening prior when absolute self-confidence is strictly required. The Congresswoman remained completely motionless while the witness spoke, entirely failing to shift or display any visible reaction as the official reminded the panel about her long legal background, her decade and a half of frontline experience, and her status as the singular individual present who truly comprehended factual documentation. She patiently allowed the chief law enforcement officer to conclude. Following that, she raised her gaze directly toward the official. Her tone remained steady and entirely conversational, resembling the pitch of an individual who had been anticipating this precise opportunity. Since you brought up the concept of proof, I intend to dedicate the upcoming 60 minutes to examining your personal records. She calmly unfastened the cover of her organized dossier. We shall commence with a situation that many individuals frequently ignore from the late summer of that specific year when you served as a state legal chief. A specific male prisoner was formally slated to receive his final capital punishment sentence. You directly reached out to the state executive leader and requested that he postpone the lethal procedure. She lifted her head and asked if the official could explain the reasoning to the panel, knowing the witness held a practiced response ready. The cabinet member had anticipated that this particular topic might surface. She possessed rehearsed talking points regarding administrative protocols, the specific duties of her former office during death penalty matters, and the complicated nature of why the fatal event was pushed back by 21 days. The lawmaker spoke while placing a paper onto the desk, clarifying that the postponement occurred without any judicial petitions, entirely lacking fresh factual discoveries, and devoid of judicial mandates or defensive attorney requests. The formally provided justification was simply a logistical timetable collision. She stared directly at the witness and declared that the calendar issue was actually a political financial gathering. The conservative politicians who were previously bobbing their heads immediately ceased their agreeable motions. You requested the state leader to reschedule a terminal judicial consequence solely because it overlapped with your upcoming political campaign launch celebration. The Texas representative carefully placed yet another printed page downward. You subsequently issued a completely open public declaration of remorse. You explicitly stated, and I am reciting your exact phrasing here, that you were incorrect. Therefore, this panel possesses your very own voluntary confession of fault. She deliberately intertwined her fingers across the flat wooden surface. I bring this matter up not because it represents the gravest topic I intend to cover this afternoon. I mention it because the event clearly demonstrates a fundamental pattern that this legislative body must grasp before we proceed any further. Whenever your private ambitions and electoral advantages have clashed with your sworn governmental responsibilities, we clearly recognize which priority you ultimately selected. We hold this knowledge simply because you provided the confirmation to us directly. The Attorney General firmly clenched the muscles along her lower facial structure. Madam Representative, I responded to that specific controversy openly and exhaustively during that very same calendar year. I expressed my profound regret in a thoroughly documented public fashion. The state executive leader and I subsequently progressed past the issue. The ultimate penal sentence was eventually administered as originally mandated. If your intention today is to claim otherwise, you only expressed remorse because journalists uncovered the truth, the lawmaker noted as the chamber's atmosphere subtly transformed. I am certainly not stating that fact simply to appear unusually cruel. I voice it because documented history reveals the demand occurred, the timetable shifted, and your department remained entirely silent until media outlets finally published the details. The expression of contrition materialized only following the widespread public revelation. That specific chronological order holds immense importance when we are analyzing the true motivations behind your administrative choices. The witness insisted the framing was deeply unjust, prompting the representative to interrupt and declare that she would explain true injustice. And for the initial moment during the hearing, her vocal tone carried a distinct sharpness. It lacked fury, but carried the piercing quality of a person who had maintained incredible restraint for an extended duration and was now exercising absolute accuracy. True injustice involves a condemned prisoner watching his final day altered, lacking any fresh defensive filings or factual discoveries, merely because the leading state lawyer encountered calendar issues. You openly admitted to this exact sequence of events personally. Your strictly recorded personal vocabulary confirmed that you acted improperly. I am simply reciting your previously established commentary directly toward your face. As the official attempted a rebuttal, the Congresswoman reached inside her organized binder, stating her goal was to highlight a consistent behavioral trend. That postponed lethal sentence serves as our initial piece of empirical evidence. The subsequent occurrence transpired during that exact same 30-day period. She positioned the primary paper onto the surface with the specific delicacy of an individual fully grasping its explosive contents and broader implications. During the late summer of that year, your department fielded media questions regarding numerous formal grievances against a specific real estate seminar program. Your official representative informed a major regional newspaper, and I possess the printed report right here, that your agency was actively evaluating the serious accusations. By that juncture, upward of 24 citizens from your state had lodged formal protests against the enterprise and its connected businesses dating back 5 years. Over 20 individuals within your jurisdiction spent massive financial sums on courses promised to transform their futures, ultimately suffering deception and seeking assistance from their top state lawyer. She gently rested the newspaper clipping flat on the table. Your administrative staff possessed full awareness regarding these struggling citizens. Your personnel had actively spent time thoroughly analyzing those situations. Over 24 separate grievances, now examining the next piece of paper. Early the following month, a specific charitable foundation authorized a massive financial draft directed entirely toward your personal electoral fundraising organization. That lucrative financial instrument was officially processed by your electoral group slightly over a week later. Moving toward the third piece of evidence. The following month, your department released a formal public declaration. You launched 0 inquiries and authorized 0 substantive legal measures. You explicitly stated that 0 active reviews were occurring during that period. Merely 4 weeks following the deposit, over 24 grievances against an individual who simply handed your political fund massive amounts of money vanished. Absolute investigative silence followed. She arranged the trio of files sequentially across the flat wood and stared downward thoughtfully for a brief second. It was the specific quietness of a seasoned attorney who recently presented undeniable proof to a captive panel, affording everyone ample opportunity to digest the reality. Over a span of less than a business week, Madam Official, your department openly claimed it was scrutinizing the real estate program. A mere 96 hours afterward, the lucrative financial payments suddenly materialized. Following that rapid transaction, the entire legal inquiry was abruptly terminated. The witness shifted her upper body directly toward the electronic amplifier. Her vocal delivery maintained the managed stability of a litigator who previously survived far more hostile environments and remained fully aware of her survival skills. Madam Representative, I have thoroughly explained this exact scenario on numerous occasions throughout the past decade. I directly requested those campaign funds from the businessman well before my agency learned anything regarding the separate Northeastern civil litigation. The historical sequence you are attempting to build is entirely false, prompting the lawmaker to interject that she was merely reciting the chronological facts aloud. These papers consist entirely of your department's internal messages, your political group's mandatory fiscal disclosures, and federal tax agency documentation. She calmly positioned an additional printed page directly onto the wooden surface. This specific item represents an internal electronic message dispatched during the early fall of that year. Your top administrative deputy was actively handling journalist inquiries demanding information regarding the educational enterprise and the Northeastern legal battle. I strongly encourage you to examine the exact timestamp stamped across this official correspondence. She rotated the paper so the text pointed directly toward the seated official. Your primary deputy possessed full awareness regarding the distant civil litigation during the first week of that month, preceding the massive financial deposit entirely. You consistently claimed you directly requested the monetary contribution while remaining completely oblivious to the active litigation during that exact period. She locked her eyes onto the witness with unflinching intensity. Those contradictory narratives logically cannot coexist as factual realities. Either your deputy possessed the knowledge and remained silent, indicating your department suffered horrendous mismanagement where critical fraud investigations were concealed from you, while you concurrently phoned the target of those probes begging for political cash, or you were fully aware all along. The official quickly countered that her personnel managed standard journalistic questions constantly without forwarding them up the chain of command. That represents the standard operating procedure for any competent governmental administration. Madam Representative, I supervised a massive bureaucratic organization spanning the state. Subordinate employees frequently finalize the crucial daily administrative judgments. Over 24 formal consumer grievances, the lawmaker sarcastically labeled as supposedly standard. The witness defended herself by asserting that only a single fresh grievance materialized during her actual administrative tenure, just a solitary occurrence. The previously mentioned 24 incidents occurred long before my leadership began. The Northeastern legal chief launched massive civil litigation during your active administration, the lawmaker reminded her, adding that the action represented far more than a lone, dissatisfied customer. That situation involved a state government prosecuting the businessman for comprehensive organized financial deception. Your official media representative assured the regional newspaper that your staff was actively scrutinizing the entire matter. Do you expect this panel to believe your primary deputy managed journalistic inquiries regarding sprawling interstate litigation yet consciously chose never to brief you, leaving you entirely blind to the situation? During the first week of that autumn month, your department openly declared its active evaluation of the controversial educational enterprise. The Congresswoman lifted the printed paper and loudly articulated the precise calendar marking. Less than 2 weeks afterward, the businessman authorized the massive financial draft. The incredibly lucrative paper draft officially landed inside your political banking ledger shortly after. Instantly thereafter, the entire administrative scrutiny evaporated completely. 0 formal inquiries occurred, 0 punitive measures materialized, and 0 justifications were offered aside from claiming the distant Northeastern litigation might secure adequate consumer compensation. She rested the documentation flat against the desk surface. You previously characterized your administrative agency as sprawling and constantly occupied. I am questioning how a massive occupied agency evaluating sprawling interstate deception allegations terminated its scrutiny merely days after acquiring vast sums of political cash from the primary defendant. The witness insisted that lifelong bureaucratic employees formulated the conclusion grounded entirely upon proper judicial standards. The lawmakers sharply demanded to know whether the bureaucratic conclusion crystallized prior to or following the financial deposit, yielding only quietness. The primary legal counsel for the witness tilted forward and softly murmured a hasty suggestion. She subtly vibrated her head left and right in disagreement. The chronological sequence serves as the definitive response to that specific inquiry, the representative noted confidently. Furthermore, that exact chronology remains permanently etched into the accessible governmental archives. She smoothly transitioned toward the subsequent printed page within her binder. The Northeastern State Prosecutor had initiated civil litigation characterizing the educational enterprise as a comprehensive deceptive operation. Your personal administrative branch was fielding open media inquiries regarding the exact same controversy. Moreover, when the scrutiny abruptly concluded, you defended the rationale as a valid subordinate decision completely circumventing your personal oversight. She steadily advanced to the following piece of printed evidence. The Federal Revenue Agency formally concluded that the charitable foundation's financial transfer to your electoral committee breached national statutes prohibiting philanthropic entities from funding political endeavors. The philanthropic organization ultimately surrendered a notable monetary penalty to resolve the violation. That specific financial punishment remains entirely accessible within the open governmental archives. The monetary contribution was definitively unlawful under national regulatory codes. I require this legislative panel to fully comprehend the severe implications of that reality. The financial exchange depositing massive sums of cash into your political ledger constituted a fundamentally illicit maneuver. The singular individual involved in that unlawful exchange who avoided any repercussions, financial penalties, or official reprimands was entirely yourself. Her vocal volume had not elevated whatsoever during the devastating delivery. There was absolutely no necessity for increased volume. The printed materials were executing the persuasive labor entirely on their own. Concurrently, several thousand former program enrollees, numerous residing within your jurisdiction who you pledged to defend as their top prosecutor, finally secured financial restitution through a massive settlement orchestrated exclusively by Northeastern state lawyers. Those victims lingered in uncertainty for incredibly extended durations. They each forfeited vast portions of their personal financial wealth. Certain individuals completely surrendered their lifetime economic reserves. Others secured additional residential loans relying entirely upon guarantees the educational enterprise aggressively marketed but entirely failed to fulfill. She aimed her gaze straight toward the seated official without blinking. While those struggling citizens desperately required their state prosecutor to champion their cause, you possessed massive sums of political cash from the individual exploiting them while your department simultaneously terminated all inquiries into his conduct. She finally released the writing instrument she had gripped tightly since the beginning. Madam Official, I intend to pose this query to you with absolute directness. Did that massive financial deposit directly influence your ultimate administrative choice to abandon all scrutiny regarding the educational enterprise? The witness delivered her response with the exact mechanical accuracy of an individual who practiced the phrasing relentlessly over multiple consecutive years. She offered an absolute rejection, insisting subordinates evaluated the grievances alongside the Northeastern litigation, ultimately formulating the correct conclusion that distant courts would secure adequate financial restitution for citizens universally. The fiscal contribution originated from friendly allies and political backers she engaged during completely standard electoral financing efforts. She steadfastly maintained she engaged in zero inappropriate behaviors whatsoever. She fiercely insisted she would never permit fiscal donations to sway her formal governmental actions. The State Moral Oversight Board, your very own local commission established by conservative politicians and operating under their direct supervision while evaluating this controversy for the government, released a documented conclusion which I possess right here. She elevated the printed paper for everyone to witness. The ruling explicitly notes, and I am reciting the verified text verbatim, that the circumstances could potentially generate deep skepticism. That represents the formal assessment of your behavior published directly by the conservatively mandated State Oversight Board, rather than liberal politicians, media outlets, or my personal opinion. The governmental entity explicitly tasked with analyzing this precise ethical dilemma officially declared that your actions warranted significant institutional doubt. She pushed the document against the desk, noting that it remains permanently cemented within regional governmental archives securely linked to your prosecutorial legacy. She carefully arranged every printed page into a perfectly aligned vertical stack. I demand that reality be formally entered into our current legislative transcripts before we proceed any further today. The atmospheric pressure within the legislative chamber had noticeably transformed. The alteration felt incredibly nuanced and difficult to immediately quantify. It resembled the type of environmental change occurring not from explosive outbursts, but through the methodical layering of undeniable proof placed gently onto the wood until the resulting visual narrative became entirely inescapable. Conservative lawmakers were entirely ignoring their cellular devices during this extended sequence. They remained intensely focused on absorbing the unfolding testimony. That visual reality served as its own powerful indicator of the escalating severity. The lawmaker flipped toward a completely fresh compartment within her organized binder. Upon exiting your regional prosecutorial role several years ago, you officially enlisted as an international operative beneath federal transparency statutes and commenced advocacy work for a specific Middle Eastern monarchy. I possess your mandatory international operative paperwork directly in front of me. She smoothed the Federal Justice Department submission flat onto the wooden surface. The legal agreement securing your firm guaranteed incredibly massive monthly financial compensations. You aggressively petitioned the executive mansion, legislative branches, and a dozen distinct national departments advancing the interests of that exact overseas regime. According to national transparency statutes, you were strictly categorized as the operative of an international entity, specifically advocating for that Middle Eastern government directly within our domestic borders. The witness deployed her defensive rebuttal with absolute immediacy. She had anticipated inquiries regarding the Middle Eastern nation since her initial job interviews, citing international human rights advocacy preceding their massive global sporting tournament. She insisted the professional arrangement was brief, completely suitable, and thoroughly transparent. A prominent senator questioned you during your initial administrative interviews regarding why you omitted the Middle Eastern advocacy as a possible ethical clash on your mandatory disclosure forms, the lawmaker reminded her. I maintain the official written record of that exact exchange. She raised the printed document for everyone to clearly observe. Your recorded response indicated profound pride regarding the advocacy and a desire that the lucrative contract had extended further. She carefully lowered the documented testimony back down onto the desk. I am entirely avoiding any debate regarding the innate value of global human rights advocacy. It undeniably possesses massive importance. I am exclusively inquiring about the ethical entanglement representing an entirely distinct and highly precise judicial matter. Therefore, allow me to utilize absolute linguistic accuracy, presenting fresh evidence, specifically the formal authorization paperwork. During the late spring of this current year, merely months into your tenure as the top federal prosecutor, you sanctioned the executive branch acquiring an immensely valuable luxury aviation vessel gifted by that same Middle Eastern sovereign dynasty. This monumental authorization strictly necessitated your personal judicial endorsement. Operating as the nation's premier lawyer, you shoulder the sole duty of counseling the presidential administration regarding the absolute legality and ethical purity of their actions. She situated the international operative paperwork directly adjacent to the massive aircraft authorization forms upon the flatwood. The sovereign state providing the incredibly lucrative present you authorized remains the identical nation you previously served as a documented operative, the exact regime paying your business massive monthly sums for advocacy before the very departments you currently dominate, she noted while building the chronology in stark statements carrying the undeniable gravity of verified reality. Several years ago, you formally registered as an international representative for that monarchy, aggressively petitioning legislative and executive branches advancing their specific goals. The following year, you paused those lucrative duties to legally shield the executive leader during his congressional trial proceedings. The legislative prosecution eventually concludes. You immediately resumed your lucrative international advocacy duties. During the current calendar cycle, you ascended to the highest federal legal office. Shortly thereafter, you officially endorsed the national government absorbing a monumental financial asset directly from that identical Middle Eastern regime. She stared at the witness, recalling that during her initial interviews, she claimed she conferred with federal morality officers who fully validated her complicated professional background. I firmly require this legislative panel to fully comprehend the organizational architecture of that specific evaluation process. The moral oversight branch that supposedly exonerated your conflicts functions entirely beneath your direct command as the top federal prosecutor. You were essentially investigated by a bureaucratic division answering exclusively to your own authority. The official quickly fired back, insisting that the administrative machinery operates identically for every single high-ranking executive department leader. The Federal Justice Department's moral oversight branch preserves absolute autonomy completely irrespective of the standard hierarchical power structure. That functional autonomy remains thoroughly ingrained within the organizational architecture. Does that architectural autonomy possess sufficient strength, the lawmaker countered, to somehow neutralize the glaring reality that the individual undergoing scrutiny maintains the absolute power to terminate the exact employees conducting the evaluation? Madam Representative, the witness bristled, that constitutes a deeply pessimistic and genuinely offensive misrepresentation regarding how our institutional morality protocols actually function. It represents a purely organizational inquiry, the lawmaker clarified firmly, entirely devoid of subjective misrepresentation. I am simply questioning if the Moral Oversight Division genuinely functions devoid of influence from the singular executive capable of terminating their employment entirely. That observation definitely fails to qualify as a personal attack. That constitutes a legitimate inquiry regarding fundamental governmental architecture. The witness sternly insisted she adhered strictly to every single relevant administrative rule. I completely documented my preceding professional engagements without hesitation. I willingly subjected my background to exhaustive internal evaluation. I comprehensively executed every single action the federal statutes demand. And immediately afterward, you sanctioned an immensely lucrative foreign present from that Middle Eastern regime, the representative noted, clarifying that this specific sequence remains her primary focus. You adhered strictly to the protocol, yet the protocol generated a result wherein the highest legal officer in the nation, previously a documented operative for a foreign monarchy, authorized the national government receiving monumental financial assets from that identical overseas regime. If the administrative machinery somehow allowed that specific outcome to materialize, Madam Official, the machinery itself desperately requires severe investigative scrutiny. The witness maintained that the judicial soundness of the foreign present underwent entirely independent evaluation. When asked exactly who conducted it, the official cited executive mansion lawyers, prompting the lawmaker to demand whether she personally influenced that analysis, generating a sudden silence. Madam Official, did you directly inject yourself into the executive lawyer's scrutiny regarding the judicial validity of the massive international aircraft acquisition? The witness admitted she supplied analytical perspective regarding the broader judicial architecture in her capacity as the top federal prosecutor. You actively supplied analytical perspective determining the legality of the executive leader absorbing massive foreign assets from a nation you previously advocated for, simultaneously disclosing this participation to the Moral Oversight Division completely controlled by your own authority. The conservative legislators had grown incredibly silent during the devastating exchange. A specific lawmaker remained gazing at an empty space above the testimony desk, displaying the intense focus of an individual aggressively deciding to mentally abandon the current disastrous proceedings entirely. I desire absolute linguistic clarity regarding what I am currently accusing you of and what I am avoiding, the representative stated firmly. I am entirely avoiding any accusation suggesting a blatantly transactional criminal exchange occurred here. I am simply declaring that you possess a substantial vocational and fiscal background intimately linked to that Middle Eastern regime. That specific background undeniably birthed a fundamentally classic ethical entanglement regarding your formal administrative duties. That you authorized a massive fiscal exchange involving that monarchy while simultaneously inserting yourself directly into the judicial scrutiny of that identical transfer. I am merely requesting this legislative panel to observe that chronological progression and formulate its independent conclusion. She prominently displayed the lengthy printed correspondence for everyone to observe. Roughly 14 days prior, nearly 400 alumni from your exact legal academic institution, the specific campus where you acquired your judicial training and swore your initial vocational pledge, endorsed an open message directed at the academic administration. She carefully positioned the document flat against the desk. The correspondence explicitly notes that the top officials' previous sworn statements were entirely defined by evasive maneuvers and a severe inability to deliver transparent, meaningful responses. Legislative officials originating from both major political factions voiced deep anxieties regarding the sufficiency and openness characterizing the federal agency's behavior. Furthermore, the authors demanded their shared academic institution publicly reinforce the fundamental moral doctrines they initially absorbed during their studies. She locked her gaze securely onto the witness. Nearly 400 credentialed attorneys, explicitly avoiding liberal organizers or electoral adversaries, but rather legal professionals who occupied your identical lecture halls, studied the exact same historical precedents, and swore the identical pledge to your shared vocational community. They observed your professional behavior and voluntarily attached their identities to an open declaration, insisting you continuously fail to embody the standards your shared institution instilled. The official attempted to dismiss the correspondence as partisan maneuvering tied to a specific individual, prompting the lawmaker to declare it an absolute flawless rebuke. The primary architect behind the message resides within your own home state. He openly declared that legal professionals learn early on that fundamental honesty holds vastly more importance than securing a victorious result. We swear a solemn pledge of honesty and openness while protecting vulnerable individuals utterly incapable of guarding their own interests. That strict moral standard universally applies to absolutely everyone, undeniably including the highest federal prosecutor. She directed her intense stare directly at the official once again. The gentleman in question certainly fails to qualify as a liberal political organizer. He operates as a credentialed lawyer inside your native region who witnessed your previous presentation before this panel and grew sufficiently disturbed to mobilize hundreds of your collegiate peers into attaching their identities to an open condemnation. That constitutes a severe vocational condemnation, Madam Official, originating from professionals educated precisely to the identical strict criteria that originally shaped your own career. She deliberately sealed that specific compartment of her binder, noting the criticism emerged from her very own community. The lawmaker then suggested they transition toward discussing the present moment, specifically examining her active administration as the top federal prosecutor. They needed to address the highly controversial, heavily guarded historical investigative documents. A microscopic alteration instantly infected the official's physical stance, remaining largely invisible to the vast majority of the chamber. However, the representative possessed 10 years of trial experience observing heavily rehearsed individuals suddenly facing inquiries they completely failed to anticipate. And she immediately identified the involuntary physical betrayal. During the late winter of the current year, the lawmaker noted, you sat for an interview on a major conservative television network. The broadcast anchor directly questioned you regarding the infamous ledger of wealthy associates connected to the disgraced financier. The specific registry driving years of widespread societal theorizing, which the survivors desperately waited to examine and which the legislative branch legally mandated your agency to publish. I maintain the perfectly typed record of that televised exchange. I also possess the actual video footage. She elevated both the physical papers and the digital media drive for the chamber to observe. You proudly declared on nationwide broadcast media to countless citizens, and I am reciting your phrasing perfectly, that the document currently rested directly upon your desk for evaluation. You explicitly added that the review represented a direct operational mandate issued by the executive leader himself. She rested the textual record and the visual media evidence flat against the wooden surface. Those constituted your exact recorded statements assigning a concrete mandate to the chief executive, strongly suggesting the ledger actually existed, remained entirely within your custody, and underwent active scrutiny. She subsequently positioned an additional printed page directly alongside the initial evidence. During the middle of the summer, roughly half a year following your claim regarding the desk, the massive federal law enforcement agencies published an official administrative bulletin. I proudly maintain physical possession of that exact bulletin right now. The bulletin explicitly declares, and I am reciting the verified text, that absolutely zero proof verified the actual reality of any such associated ledger. She locked her eyes onto the seated official. During the winter, you claim the registry rests directly upon your personal workspace. By the summer, your exact agency publicly insists the registry remains entirely fictitious. A profound moment of absolute quietness consumed the chamber. Madam Official, were you actively deceiving the public during the winter? Or are you actively deceiving them currently? She demanded, instantly causing the entire chamber to erupt into chaos. The wooden mallet slammed against the sounding block 3 distinct times. Liberal lawmakers aggressively leaped out of their comfortable chairs. Conservative legislators became incredibly motionless, displaying the precise stiffness of individuals actively computing whether their lack of reaction would visually damage them politically. Media journalists rapidly, aggressively, violently pivoted their recording lenses directly toward the official's expression. A visual journalist occupying the primary seating tier captured digital frames in rapid succession. The witness loudly insisted that the specific inquiry and its underlying construction were entirely unacceptable and deeply unprofessional. It aggressively presumes malicious intent when numerous alternative logical justifications exist entirely. I am explicitly requesting that exact justification, the lawmaker replied, her voice cutting cleanly through the chaotic background noise echoing throughout the chamber. You previously proclaimed the registry literally occupied your physical workspace. Your administrative branch eventually concluded the registry remained entirely mythological. Those represent your personal statements colliding with your agency's statements, and I demand you inform this legislative panel regarding which version reflects reality. The official desperately countered that vocabulary deployed during casual televised interviews frequently lacks absolute strict accuracy. The phrase indicating the document currently rests on the desk awaiting active scrutiny, that constitutes an incredibly precise, entirely literal declaration delivered within the immediate present tense. Which exact vocabulary term inside that specific phrasing lacks absolute clarity? The witness desperately attempted to blame the broader surrounding conversational atmosphere of the televised broadcast, a different lawmaker having remained entirely silent for nearly 3/4 of an hour from the far side of the panel, suddenly demanded they broadcast the actual video. I possess the digital media file entirely prepped for immediate playback. Would you prefer that I initiate the broadcast immediately for everyone to witness? The official hurriedly insisted that executing such an action remained completely unrequired. Then clearly explain your intended meaning, the representative demanded, noting that the victim seated inside the chamber spent years anticipating that exact registry. The broader national citizenry has patiently anticipated the release. The legislative branch successfully enacted statutes mandating your agency publish the controversial files largely due to massive societal pressure demanding this exact form of governmental openness. Yet you willingly appeared on nationwide broadcast media to inform countless citizens that the registry physically occupied your personal workspace. If you somehow utilized incorrect phrasing, clearly defined the exact message you originally intended to deliver, if you avoided any linguistic errors, properly explained the ultimate physical fate of the highly sought registry. The witness shifted her upper body aggressively toward the desk. Her vocal delivery finally adopted a noticeably sharper, more combative tone. Madam Representative, with all due courtesy, I provided vastly more openness regarding this controversial scandal than any previous governmental administration managed. I have successfully authorized the publication of countless historical records. I have willingly occupied this chair for nearly 200 minutes fielding your inquiries. I publicly labeled the disgraced financier an absolute terrifying monster. I exhausted every single tool within my administrative authority, providing the survivors the total clarity they unquestionably earned. They physically elevated their arms, the Congresswoman suddenly interjected. The witness instantly halted her defensive speech. Every victim present inside this chamber, when questioned by another lawmaker regarding who lacked communication from your agency, collectively elevated their arms toward the ceiling without exception. That occurred earlier this afternoon, scarcely 60 minutes prior inside this exact location, she noted while staring at the official. That reality absolutely fails to represent genuine administrative openness. That merely constitutes the carefully manufactured visual illusion of openness. A massive functional distinction exists between those two concepts. Furthermore, the individuals occupying the rear seating tiers understand the painful reality of that distinction perfectly. The entire legislative chamber plunged into absolute suffocating quietness. The official immediately launched into rehearsed attacks against previous administrative shortcomings, liberal political leadership, and historical federal agency failures. She had rigorously practiced this specific aggressive misdirection tactic. She executed the maneuver with the flawless precision of an individual who survived by successfully deflecting hostile criticism throughout her entire career. I prefer to transition toward an entirely different subject, the lawmaker stated smoothly, delivering a phrase carrying the undeniable finality of a heavy vault sealing shut. She plunged her hand deep inside her organized binder, extracting a printed page bearing an official logo the witness recognized instantly before the reading commenced. This represents a formal declaration originating from a leading panelist slightly over a week ago following revelations that your agency actively tracked the digital queries of elected lawmakers while they evaluated heavily sensitive historical records. The legislative chamber finally descended into authentic, terrifying silence for the very first time throughout the massive proceeding. It lacked the standard hush accompanying manufactured theatrical drama, completely replaced by the heavy stillness of a crowd realizing an incredibly dangerous accusation had finally surfaced. Federal lawmakers, Madam Official, the chosen delegates of the national citizenry, actively executing their foundational supervisory duties by examining materials the legislative branch legally forced your agency to surrender, yet your department secretly monitored their digital investigations. She firmly rested the printed page against the desk. I desire to present an incredibly straightforward inquiry directly to you. Precisely which legislative code grants the federal law enforcement agency the explicit power to surveil the digital behaviors of elected officials actively conducting their legal supervisory mandates? The witness parted her lips, attempting to formulate a response. I demand a specific judicial code, the representative fiercely insisted. I firmly reject administrative justifications, broad defense architecture excuses, or vague gestures toward hidden operational protocols. I am unable to locate any explicitly titled legislation permitting the administrative division, the massive apparatus you currently command as the premier federal prosecutor, to actively spy upon lawmakers while they evaluate materials they hold absolute legal authority to examine. The deafening quietness following that devastating accusation stretched for nearly a dozen brutal seconds. The representative's primary deputy, observing the unfolding disaster from the chamber's perimeter, silently tallied every agonizing moment. The official's primary federal counsel tilted his body aggressively and muttered incredibly hurried advice. The witness vibrated her skull side to side, executing a microscopic movement remaining largely undetectable. Our agency remains actively evaluating the foundational judicial justifications, the official finally managed to utter. Those specific syllables crashed into the chamber, carrying the identical devastating impact of a massive boulder plunging into perfectly calm water. The previously mentioned lawmaker positioned across the sprawling panel instantly demanded clarification while aggressively interrupting. Did you honestly just proclaim you are currently seeking the judicial justification for severe actions your agency previously executed in the past? The witness stammered that the judicial architecture regulating supervisory procedures remains incredibly complicated and difficult. I am fully aware the architecture remains deeply complicated. The lawmaker aggressively fired back. I am specifically demanding whether you confirmed the absolute legality of the surveillance prior to authorizing its immediate execution. That inquiry demands nothing beyond a binary affirmative or negative declaration. The official desperately attempted to pivot toward her massive judicial advisory squads. Did you directly sanction the active digital surveillance of legislative officials? Answer either affirmatively or negatively immediately. The witness deflected by claiming technical procedures of that specific caliber typically reside solely within subordinate administrative channels. Therefore, you remained entirely ignorant regarding the active surveillance occurring, the lawmaker concluded confidently. The official fiercely objected to that specific summary of her knowledge. Consequently, you undeniably possessed full awareness regarding the ongoing operation. The witness desperately insisted that judicial evaluations remain heavily active, rendering any definitive classifications deeply unsuitable for the present moment. Madam Official, the representative's vocal tone sliced effortlessly through the chaotic overlapping arguments. The aggressive lawmaker and the defensive witness immediately halted their loud bickering. You literally just combined two contradictory concepts within a singular response, claiming you never denied knowledge while simultaneously insisting subordinates manage the actual technical execution entirely. She completely failed to address the core inquiry directly. She willingly tackled completely different topics entirely. She utilized massive evasive maneuvers constantly. She launched aggressive defensive counterattacks. She referenced historical governmental regimes, her previous legal victories, the specific initiatives generating immense personal pride, and the righteous campaigns she supported. However, she utterly neglected the most crucial demand, allowing the chamber to grasp reality while the historical transcripts immortalized the failure, ultimately triggering formal ethical withdrawals, sparking severe internal federal probes, forcing the academic institution to publish a condemnation, prompting an official administrative retraction inside the National Archives, convincing a Southern legal scholar to remain dedicated to their studies, while the subsequent investigative dossier awaited review. Financial corruption perpetually generates an incredibly visible historical footprint. The brilliant legislative representative successfully tracked those corrupt footprints straight toward the absolute pinnacle of federal power. The committee desperately required absolute clarity. Did you personally comprehend your agency actively tracked legislative officials reviewing sensitive files? I remained aware secure protocols operated surrounding the sensitive material evaluations occurring throughout the afternoon. Did the security protocols target the officials or the actual historical materials? The evaluative environment encompasses a massive variety of protective measures protecting everyone involved. Which specific elements suffered the security tracking, the lawmakers, or the files? 8 agonizing seconds of pure quietness dominated the massive legislative chamber. You represent the premier legal prosecutor operating within this entire nation. You shoulder the absolute responsibility guaranteeing the massive administrative branch functions strictly within lawful boundaries. Yet you occupy that chair entirely incapable of confirming whether you understood your agency monitored lawmakers or what judicial codes supposedly permitted the terrifying behavior. That completely fails to constitute a valid defense, Madam Official. That literally represents an absolute, undeniable confession of monumental administrative failure. She permitted the massive chamber ample time to fully absorb the devastating reality. She subsequently directed her gaze toward the rear seating section where numerous women maintained the heavy stillness of individuals traveling massive distances just to face further delays. Victims occupy this exact chamber alongside us this afternoon. Her vocal delivery shifted octaves, abandoning softness for intense, devastating calculation. Every single syllable landed carrying immense, heavy, undeniable intentionality. They endured unimaginable delays lasting for several consecutive years. They previously visited this exact structure weeks ago when another lawmaker questioned who lacked communication from your agency. Everyone elevated their arms toward the ceiling without a single exception. These individuals represent human beings suffering extensively, not cheap political props. Their abusers thrived for decades while massive governmental institutions deliberately ignored the devastating reality. They traveled here hoping the nation's premier legal prosecutor might finally provide closure regarding their unimaginable trauma. When a colleague demanded you face them, you aggressively refused the request entirely. I demand you face them immediately and explain why their historical files remain heavily censored. Explain why your agency claimed a registry existed before abruptly denying reality. Clarify why your department tracked lawmakers rather than answering their legitimate inquiries. The official rotated her body scarcely halfway toward the back row. The media lenses captured the pathetic motion perfectly, noting she avoided any direct visual contact. I offered my deepest sympathies to every victim, she mumbled quietly. I publicly labeled the disgraced financier an absolute terrifying monster. I already stated my profound regrets repeatedly throughout the afternoon. They elevated their arms, the representative interrupted with brutal calmness. Every single victim raised their hands when questioned about your agency's complete lack of basic communication. The official offered absolutely nothing capable of genuinely addressing that devastating reality. The lawmaker stood upward with deliberate, unhurried, terrifying professionalism. She gathered her organized binder lacking any manufactured theatrical energy. The entire chamber fully comprehended the devastating reality before another syllable echoed. You previously boasted regarding your massive 15-year legal background identifying genuine evidence. I absolutely believe you recognize evidence, which guarantees you understood exactly where this specific hearing inevitably headed. You possess incredible intelligence, massive training, and extensive trial experience. You instantly recognize when printed records narrate a history the witness simply cannot contradict. Allow me to summarize the documented narrative perfectly for the historical transcripts. She refused to utilize a visual presentation board entirely. She simply read the devastating story the assembled documentation already established perfectly. The chronological sequence perfectly captures your massive ethical failures immediately. Your private ambitions constantly override your sworn governmental responsibilities flawlessly. Whenever your personal advantages clash with administrative duties, you eagerly sacrifice the public. You postponed a lethal sentence strictly to accommodate a political financing celebration. You terminated corporate fraud investigations precisely when lucrative campaign checks materialized rapidly. You eventually secured immense wealth advocating for an overseas Middle Eastern regime. Upon acquiring federal power, you immediately authorized massive presence from that exact monarchy. Your own moral oversight division lacked genuine independence to properly evaluate the entanglement. You publicly claimed scandalous registries existed before your agency officially retracted the statement entirely. Furthermore, you illegally monitored elected lawmakers actively investigating those highly guarded historical documents. You spent the afternoon weaving a deceptive narrative transforming legal actions into corruption. I spent the entire afternoon literally just reciting your own verified documentation aloud. I added absolutely nothing. I simply chronologically arranged the previously existing reality. Everything resting on this desk originated entirely from your own agency or governmental oversight boards. I avoided characterizations entirely, relying exclusively upon reading your own terrifying historical records. Financial corruption perpetually generates an incredibly visible, undeniable historical footprint. You merely require immense patience tracking it from the absolute beginning to the final conclusion. Some professionals construct massive careers exploiting the void, separating their promises from their hidden actions. You thrived within that dark space, bridging accountability and absolute administrative immunity. Jasmine Crockett successfully tracked those corrupt footprints straight toward the absolute pinnacle of federal power.